Hello, everybody. My name is Kamran Salour. I'm a senior trial attorney here at Callahan Blaine in Santa Ana, California. And I am your presenter today on the riveting discussion of deposition preparation. And today we're going to focus on what's called the 3 Ps to preparation. Before I get started, I want to remind everybody that even though this is a webinar and you're just going to see me talking to you, it is intended to be interactive. And I believe there is a mechanism on your screen to ask questions, and I encourage you to ask questions. Send in your questions as they come to you, and then we'll take a break about an hour into this presentation. And during that break, I will review the questions, and I will try to answer as many of those questions as I can. If I don't answer your question, please don't take that as a slight. I'm not questioning your question. I may be covering that material at another part of this presentation, and I may just not have enough time to cover all of your questions. But I do encourage you to ask questions, and there will be a break about an hour into this presentation. So with that, I want to get started. And we're going to talk today about preparation. And you may be wondering, why are we talking about preparation and not about deposition techniques, right? After all, we're lawyers, we're litigators. Deposition technique and questions that you ask, techniques that you use during the deposition can be very important. They can be very helpful to your case. And if you don't know those techniques, it may impact your ability to get a good result for your client. And that's all well and true, but there's a couple of reasons why we're going to focus on preparation today. One, as I said, although this is supposed to be somewhat of an interactive webinar, this is really, you're going to be listening to me talking and really to talk about deposition techniques, or to really practice deposition techniques. It needs to be more of an interactive setting where we'd have witnesses who are actors come in and play the role, and we would have a common case theme and outline, and we'd be able to do some give and take and a little bit more interactive. But the other reason why we're going to talk about preparation is because preparation is key. And while I hope throughout this presentation you gather lots of great information, I hope you're jotting down notes as we speak, and you're just going to be full of useful tips and techniques by the end of the presentation. If there's one thing that you can take away from today, I want that to be that preparation is paramount. Because without a solid preparation, you're not going to take a good deposition. Without solid preparation, you're not going to effectively defend the deposition. And so with that, let's begin. So we're talking about the 3 Ps to preparation. So what are those 3 Ps? Okay, we're going to talk first about preparing yourself. Then we're going to talk about preparing your client. And finally, we're going to talk about preparing for opposing counsel. Now, while I've compartmentalized these categories for presentation purposes, and it's also helpful for preparation purposes to have the entire deposition process sort of in more digestible bite-sized pieces, it's important to understand that this is a very fluid process. So as you're preparing yourself, you of course are going to be taking steps to prepare your client, and you're also going to be taking steps to prepare for opposing counsel. So these are not mutually exclusive categories, but they are set up this way to help guide the presentation and also guide you as you do prepare your client to defend a deposition or to prepare to take a deposition. Okay, so we're going to start with the first P, which is preparing yourself. Okay, so it starts with you. Is really the framework from which we're going to begin. Taking or preparing for a deposition is about obviously preparation, but it's also about control, and it's about optics and perception. And I really want to focus a lot today on the optics and perception that comes into play and how preparation plays a key role in that. And the best way to do that is to start with you, because you're in control of the entire deposition process, okay? And this is true if you're taking the deposition, and this is true if you're defending the deposition. So how do we go about preparing ourselves for a deposition? Well, there's rules, as with everything. The first rule is, what do you need to know? Now, you're going to have to know the facts of the case. It means you're going to have to know the pleadings. You're going to have to read deposition transcripts. You're going to have to read discovery responses. You're going to need to know the documents. All right, you're going to have to know key emails, key agreements. You need to know these documents very well. And you have to, of course, know the law, okay? Sometimes the law may be obvious. We may be talking about a very, a car accident or something where we have, duty, breach, causation, damages. And knowing the law may not be, the law is not controversial in that area. We may have a situation where liability is stipulated and we're just focused on damages. And the law of damages might be a little more settled in this particular area. So take that with a little bit of common sense that you need to know what the relevant law is, and if there are subtleties or nuances to the law, or if it's an unsettled area of law. Sometimes there's unsettled law, and that's sort of what the case is about, and that's very important to have a great handle on that case law. Now, another thing that might not seem so obvious, right? It's pretty obvious if you're going to take a deposition to know the case, know the facts, know the documents, but you should also know the local rules. And this is important, obviously, because when you're taking the deposition, there's times where you're going to run into opposing counsel that is going to be difficult. Opposing counsel is going to object, is going to instruct the witness not to answer on questions that are, fair game. And you need to know what procedures are in place for you to, challenge or put an end to this type of practice. And one way to do that is to know, hey, does my judge allow for telephonic conferences on certain days to resolve discovery disputes? Does my judge allow for sort of ex parte hearings before filing or preparing discovery related motions to resolve these disputes? These are important things to know, and that gives you a little bit of leeway, and we'll talk a little bit more about this when we're into part 3, which is about preparing for opposing counsel. But this gives you a little leeway into knowing what avenues you have for relief, so to speak. Now, another reason why this is important is, and we're going to talk more about this, is about perception, okay? If you are aware of the judge's local rules, that creates the perception to, let's say, opposing counsel that you're on top of things, you know the rules, you know the law. Opposing counsel is less likely, not guaranteed of course, but less likely to try certain tactics to try to, quote unquote, pull one over on you. It also creates a strong message to the client, to your client, if you're there defending the deposition, that, hey, the client says to him or herself, I'm in good hands, my lawyer knows what's going on, my lawyer is in charge. And conversely, if you're taking the deposition and you're asking what you think are fair questions, and the opposing counsel is, trying to stop you from doing so, and you pull out, hey, the judge doesn't allow for this. I'm going to call the judge up right now, and we're going to resolve this. That's going to put the client, or the opposition's client, on notice too that, hey, my lawyer is up against a pretty good adversary here, and that's going to have a lot of value to your case. It's going to be hard to quantify, but it's going to pay dividends down the road, okay? And of course, you want to know the rules because you don't want to run into court and try to file an ex parte on discovery, and the judge has, in the standing orders, there's no discovery heard on an ex parte basis. You're going to get the wrath of the judge, okay? So, rule 1 is about what you need to know. Now, rule number 2 is why do you need to know it, okay? Now, this may seem pretty obvious, and you might be asking yourself, well, this guy just spent 10 minutes telling me about what I need to know, and the reason why I need to know it is because I need to be prepared for the deposition. And that's all true, and that's valid. But it's important to know why you need to know this information. And really, to answer that question, you need to know, why am I taking this deposition? What is the purpose of this deposition? Now, too often, we'll have attorneys taking depositions. They're well-versed with the facts. They're well-versed with the documents. They're well-versed with the law. They've taken hundreds of depositions. They understand the process. They understand the procedure. But they still don't take an effective deposition simply because they don't know why they are taking the deposition in the first place. Let me give you an example. couple of months ago, I was defending a client in it's a defamation lawsuit. The court ordered my client to be deposed for a limited purpose deposition. And the purpose for the deposition was to determine whether the false police report exception to the anti-SLAPP statute applied. So it's a very discrete issue on a very discrete topic, basically on one document, a police report. And essentially, the question that opposing counsel had to ascertain was, did my client knowingly file a false police report? 6 hours later, this deposition was 6 hours long. The client maybe spent 15 minutes, if that, I'm being generous here, on the actual police report. Didn't ask a single question about what information my client had in his possession before he filed the police report. Didn't look at any of the documents that my client relied on to file the police report. Didn't question the veracity of those documents. Didn't question the veracity of anything in that police report. Okay, so what does this mean? Well, from my standpoint, it's great because now opposing counsel wasted 6 hours on a deposition and got absolutely no information. Okay, so what does that mean for the attorney taking the deposition? Well, it means lots of things. Number one, that attorney wasted everybody's time, wasted the client's money, got absolutely nothing from the deposition. And now, more importantly, my client looks at that attorney and says, this attorney doesn't know what he's doing. I'm not inclined to settle this case because I think if I take this case to trial, that attorney is going to show his inexperience or his lack of skills during trial. So it really emboldened my client and really hurt opposing counsel's chances to settle. And a lot of that could have been avoided had the attorney known, why am I taking this deposition? So it's something very simple, something very obvious, but it's something that is often ignored or in some instances never even considered in the first place, okay? So why do you need to know that information? You need to know why you're conducting the deposition. You need to know, do I want this witness because this witness has specific information about a contract? Do I want this witness because this witness was the eyewitness to an accident? Is the witness a plaintiff in a slip and fall, and I want to know if the plaintiff was aware that there was a spill in the area before the plaintiff fell? There's lots of obvious reasons why you want to take a deposition. Also, you want to know perhaps, hey, I need this witness because this is the only witness that I can rely on to authenticate a key document that I'm going to need at trial. This witness was the only other person involved in the negotiations of the contract. I need to close out what this witness knows. I need to figure out all the conversations this witness had, with whom the witness had those conversations, and what was the context and content of those conversations. And of course, depositions the reason why you're taking someone's deposition, there could be lots of reasons, right? It could be all of those things, it could be none of those things, but there has to be a reason why you're taking the deposition, and you need to know that reason. And knowing that reason has lots of I guess, positive effects. Number one, it's going to help your preparation. Now, we started this process by talking about knowing the facts, knowing the law, knowing the case. Now, and sometimes a case is small enough where the universe of documents is small, the law is non-controversial and it's settled. The facts could be just, it's a simple dispute over a contract, and it's really, does this word mean X or this word mean Y? And so your preparation in terms of knowing the facts, knowing the law, knowing the documents is manageable, and it's a pretty discrete process and something that can be done. Now, other times you're on a case where you have millions of documents, you have multiple issues running in parallel, and sometimes the number of attorneys on a case is so large that, let's say you're focused on contract issues and the other team is focused on tort issues, and there's a third team focused on damages issues. So you need to know why you're taking this deposition. If the deponent only knows stuff about the contracts, well, in your preparation, it's not going to do you any good to prepare studying about tort issues when you're preparing, when you're going to depose somebody about contracts. And the same is true, of course, for your preparation of your client. When you're preparing the client, if the client is only only has information on contracts, going over case theories and case analysis and going into the weeds on documents that have absolutely nothing to do with the contract is going to do your client a disservice, because that's preparation time that could have been used more effectively. Another reason why you want to know why you're taking the deposition is you're going to avoid frustration, because it's really not possible in a large case to review every single document and to, more importantly, really know the importance of that document, because you're just not able to process that type of information. So knowing why you're going to take this deposition is maybe the most important part about preparation, because it's going to guide the other parts of preparation, which is knowing the facts, knowing the case, knowing the law, and knowing the documents. Okay? Now, there's other reasons to prepare in terms of knowing why you're taking this deposition. I did a deposition many years ago where it was a breach of contract dispute. We were the defendant. The plaintiff was a video game manufacturer, had entered into a contract with our client, which was a video game maker, and the client had a contract in place that said we will give you 100 games for $100. The plaintiff said no, the contract said we would give you 100 games for $50. And so the universe here was very small. We had a purchase order, which was basically the contract, and so the preparation here for this witness was to know pretty much everything, because the witness that I was deposing was really the only main witness in the case. Is the only witness that had knowledge of the contract, was involved in negotiations of the contract. So I went through the process, right? I learned the facts, I learned the law on contract interpretation, and I went through the documents, and I went through all the documents, and in fact, as I went through the documents, I found that what the plaintiff was saying was the contract was in fact not the contract, because there was a typographical error on that purchase order. And minutes after that purchase order went out, our client sent out an email saying, "Oh, sorry, there's a typo. Here is the correct purchase order." So we're doing very well there in terms of the contract. So what did the plaintiff do in that case? Well, he decided, I'm going to say it's no longer a written contract, it's an oral contract. So the deposition, as part of that deposition, we had to know everything that this witness spoke about the contract. So all the phone conversations, all the in-person meetings, every conversation imaginable that this witness had with respect to the contract. And so during the deposition, we closed out the witness and limited the witness to, he identified 3 specific conversations he had about the contract. Okay? That was in the deposition testimony, in the transcript. Fast forward to trial, the witness is on the stand, witness starts talking about this 4th conversation that never happened. We pull out the deposition transcript, we show question and answer, how many conversations you have about the contract. 3, when were those conversations? January, February, March. And now you're talking about a 4th conversation that happened in May. You're not allowed to testify about this. So needless to say, we're victorious in that case, in part because we knew what we needed to do in terms of preparation. We were prepared when it came to the documents. We were prepared when it came to the facts. And then we're also able to adjust on the fly and now know that if you're switching from a written contract to an oral contract, what do we need to do? We need to find out everything that this witness knows, and we did so. Okay? Now, I just talked about a victory, and winning is obviously, as a litigator, is important, right? You want to win the case. Now, at the deposition stage, it's hard to win the case. It's very rare that you're deposing, the defendant and the defendant, deposing the plaintiff, and the plaintiff says, you know what, I give up. I'm going to withdraw my case. Your questioning is too good. That hasn't happened yet for me. Maybe it's happened for some of you, but so you're not going to win the case at the deposition stage, but you should be able to get key admissions if you're taking the deposition, which will set you up for victory. If you are defending the deposition, you want to, of course, avoid those key admissions. You want to avoid those closeouts, and we're going to talk a little bit more about that as this presentation goes on. But there's other ways to win, right? So if you're signed up for this CLE, chances are you're relatively a junior attorney, and that means there's other people above you in the totem pole, and believe you me, I know that all too well. So you want to win sort of at work and win within your circle, and that goes back to sort of the perception and the optics, okay? Now, if you do a very good job in your deposition preparation, a lot of times as a junior associate, you're preparing deposition outlines for the senior attorneys on the case. If you do a good job with that, that's going to give you some cachet within the firm. It may lead to some more opportunities where you actually get a first chair role in deposition as opposed to a second chair role. It's also going to give you some goodwill with the partner. It's going to hopefully bring some goodwill for you and the client. And it's also going to create the optics and the perception with opposing counsel that, hey, these guys are formidable adversaries. They're well prepared. They're organized. They know they have a goal, and they're able to execute that goal. And that goes a long way when it comes to settling the case. Okay? So, what we're going to do now is we've talked about two things. We've talked about what you need to know, why you need to know it, and now we're going to talk about showing what you know, right? So, obviously, if you are taking a deposition, you're able to illustrate what you know through the questions that you ask, through the documents that you show, and things of that nature. But again, then we're talking here about preparation. And so how are you going to show through the preparation process that you are on top of things, that you are well prepared for this deposition? Well, there's a couple of ways to do that. And really, we're talking about control, right? The first thing I said was preparation starts with you. You are in control, and this is true if you're taking, this is true if you're defending the deposition. So how do you show in your control? Well, it's a little bit easier when you're taking the deposition because it's sort of on your home turf, right? So you can decide, you decide to set up in the room, right? I'm going to sit here. The court reporter, I want you to sit here. Videographer, I want you to stand there. I want to be facing this side of the room. I want my opposing counsel, I want his back to the door. Or I know come 3 o'clock, the sun comes in a really harsh angle and becomes very hot over here, so I'm going to have opposing counsel sit here. When you meet with the court reporter, have a business card ready, have the case caption ready. These are little things that seem to go a very long way with court reporters and videographers in terms of you being the attorney here, showing that you really are in control of the process and this is not your first rodeo. Okay? Another thing to do is when opposing counsel comes in, have them wait in the lobby. You're telling opposing counsel and opposing counsel's client, I'm in control, this is my deposition, it starts when I say it starts, it takes place where I say it takes place, and you're going to sit where I tell you to sit. And again, these are very subtle, minor little tactics and tricks, which obviously aren't going to win your case by any means, but they certainly have a nice perception effect and an optic effect that shows that you are in control, you are in charge, and certainly creates the impression for the opposing counsel's client that, hey, I'm in for a long day here. I'm going to be questioned by an attorney who is in control and knows what he or she is doing. Now, the last thing you want to do is you want to dress the part. You want to put details to your outfit. You want to show because that reflects, just from a perception standpoint, that this guy or this woman is very focused on details. They do it when they dress. They take time to put that together. That means that when they're doing their deposition preparation, they take time to put that together. Now, I know a lot of attorneys that say, well, I'm taking the deposition, even though it's on video, I'm not going to be on camera. I'm just going to wear, jeans and a t-shirt, and I'm going to take this deposition. I want to be comfortable. I'm in the room all day. And I think that's a mistake because, again, it's about perception, and if the client comes in and sees, the questioning attorney is wearing jeans and a t-shirt, client's going to think, well, this guy's taking this deposition pretty casually. It's probably not that important. He's probably not that well prepared. I feel pretty confident right now, as opposed to if the client comes in dressed to the nines, the client might be more likely to be intimidated. Hey, whoa, this guy, he's very successful. Look how he's dressed. He must know what he's doing. I'm very scared. I'm very intimidated. So obviously, it's not as cut and dry and black and white as that, but it does add some value. It reminds me of an episode of Curb Your Enthusiasm, which this gentleman was going to see a lawyer to revise his will, and he had hundreds of millions of dollars, I think, and he wanted to give some of that money to Cheryl David's charity, which was Larry David's wife at the time in the series. And the guy walks into the lawyer's office, and it's Friday, and it's casual Friday at the firm, and the lawyer is wearing denim from head to toe, and he's got cowboy boots on, and the guy takes one look at him and says, I got hundreds of millions of dollars here I'm talking about. I am not going to trust you with any of my money because you're dressed like a cowboy. And he walked out. And so obviously, that's a little bit exaggerated for comedy there, but there is a perception effect in how you're dressed, and I think that's very important. It sends a very important message both to opposing counsel and to opposing counsel's client in terms of this guy means or girl means business, and we're up for a fight. Okay. So now we've talked about some do's. I just want to talk briefly about some don'ts. Okay. So, number one, don't forget to confirm that the deposition is going forward. So, nothing makes you look less prepared than having a room of, have your client at a deposition and it's not going forward, or you're sitting there waiting for opposing counsel to come and your deposition is not confirmed. That's obviously not going to bode well for you in a number of ways. So it's a very simple step is to obviously confirm that the deposition is going forward, but it's something that people do forget. Fortunately, I have not forgotten that. Unfortunately, I have forgotten this next one, which I put here, which is do not forget to confirm that the court reporter and the videographer are coming. So I was probably a second or third year attorney. I just started at a new firm, and the senior partner was taking the deposition of a CEO of a Fortune 500 company in Canada, which was 3 hours ahead. And I had spoken to my secretary, had her make the arrangements for the court reporter and videographer to be at the location in Canada at 9 a.m., which was 6 a.m. Pacific time in California. Driving to work, 5 o'clock, I have email. Where's the court reporter? Where's the videographer? Did you confirm? I'm thinking to myself, of course I confirmed. That deposition doesn't start for another hour. I'm sure they will be there. Get on the phone, call the court reporting service. We don't have any record of you confirming a court reporter or videographer. So obviously I'm in panic mode. Fortunately, I'm able to pull some strings, and we're able to get a court reporter and videographer there. A couple of hours late, that ate into our deposition time, which didn't prove to be problematic, but it certainly was a black eye for the lawyers taking the deposition. They looked ill-prepared. It was embarrassing. It was obviously very embarrassing omission on my part, and it's something that it's very easy to avoid and something you want to avoid. So I put that one there as sort of personal experience. Always confirm the court reporter and the videographer. Okay. Next one I want to talk about is local rules. I talked about this in the do section in terms of do know the local rules, the judge's rules, and it's so important that I'm putting it here again, telling you don't forget to know these rules. Okay. The other thing you want to do is write out your questions. Now, there's a couple of reasons why not to write out your questions, and most of those reasons go into play when you're actually taking the deposition, okay? Because it impacts your ability to listen to the answer and ask pertinent follow-up questions based on the answer to your question. But that's more of a deposition taking tactic. From a preparation standpoint, it just screams amateur hour, right? It looks like this is your first deposition. You're so unsure of yourself, that you have to go on a script and you're going to go through question by question by question. And if I see a questioning attorney have a list of questions written out, I immediately get the sense that I'm in for an easier day if I'm defending that deposition, because I know that this attorney is either ill-prepared, inexperienced, or lacks confidence, or some combination of the three. And that obviously affects how your opponent, in this case, is going to respond. So don't write out your questions. And this is sort of tied in, again, this is sort of a free deposition taking tip, which is listen to the answers to your questions. So I don't know if you guys can see this on your screen, but here's just an example of an attorney who, for whatever reason, isn't listening to the answers to the questions. So I'm just going to read this. So we have a lawyer who is the witness, and then, we have a lawyer and we have the witness. So the lawyer says, and the witness here is a doctor. So the lawyer says, "Doctor, before you performed the autopsy, did you check for a pulse?" And the doctor says, "No." So now the lawyer feels emboldened. "Well, did you check for the blood pressure?" Doctor says, "No." Now the lawyer is feeling really great. "Did you check for breathing?" Doctor says, "No." So then, is it possible that the patient was alive when you began the autopsy? The doctor says, "No." Now the lawyer continues on. "Well, how can you be so sure?" The doctor says, "Well, the patient's head was sitting in a jar on my desk." The lawyer continues, "But could the patient have still been alive nevertheless?" And of course, now the doctor can't resist and says, "Yes, it is possible that he could have been alive and practicing law somewhere." Okay, so again, if you look at this transcript, you're going to ask yourself, well, what is the purpose? Well, why is this lawyer taking this deposition, right? So from the sounds of it, it looks like there's some question about either the doctor's, I guess the credibility or the reliability of the doctor determination that the individual has died. But how do you get to that? Well, you got to know the facts, and you should know the facts that the deceased's head was severed and the deceased head was in a jar. Okay, so you got to know that before you take the deposition, so you don't look foolish. Okay. The other thing you need to know is to listen to the answers to the questions here, because after I would have stopped much sooner here, of course, but after the doctor says that the head was in a jar, that's probably a good time to stop that line of questioning, because you've already exposed yourself to ridicule for sure, but you've also, from going back to the optics and perception, now you've also really told everybody either I'm not prepared for this deposition, or I'm not listening to what the witness is saying, or I really don't know why I'm taking this deposition. I'm just asking questions to ask questions. All of those things are definite no's, and a lot of this could have been cured through the preparation process. Okay, so that's preparing yourself. And so to summarize, when we're talking about preparing yourself, we want to know the facts, we want to know the documents, we want to know the law, we want to know the rules that the judge has. We want to know, as we go through this, why is it that I need to know this information, right? Why is this information important? Is it because this witness has unique knowledge about a specific incident? Is it because this witness can only authenticate a document that I will need for trial? Is it because this witness was the only person involved in negotiation? Is it because this witness knows, we need to find out what this witness knows, and so it's more of an investigative deposition, you need to know why you are taking this deposition, okay? And then the more of the optics part is showing what you know, showing you're in control when it comes to setting up the deposition room, when it comes to controlling the time that the deposition begins, controlling when opposing counsel is allowed into the room, controlling just sort of the entire process. And then we talked about some don'ts, which is really all falls under the umbrella of preparation in terms of confirming the attendance of everybody, including the court reporter and the videographer, and really making sure that you know the facts, the case, and the law. Now, again, I want to preface all of this with a caveat that the preparation process, you know, what I'm explaining right now is obviously preparation in a vacuum. It's not taking into account the time you have before the deposition, so how much prep time you have, how much lead time you have. It's not taking into account the budget that you have, right? Some cases I've been on that, you know, the clients are spending $1 to $2 million a month, and the client's not going to flinch if you're spending, you know, days and days preparing for the deposition, going over documents and pleadings and deposition transcripts and the like, and really, you know, preparing a strong, you know, I guess outline of attack in terms of what it is you want to achieve at the deposition. Other times you just don't have the budget to devote as many hours as you would want. So you need to really approach the preparation for yourself with common sense. And again, that means if you have 1 million documents on the case, why are you taking this deposition? Focus on the documents that are going to be pertinent to the why, right? What is the why, and how are you going to achieve that why? You need to focus on the documents that are going to get you there. You need to focus on the pleadings and the, you know, the deposition transcripts that are going to get you there. Okay. What I like to do when I prepare for a deposition is I go through the, you know, obviously I go through what I've talked about here, the facts, the documents, the law, and knowing the local rules and everything. But I prepare a binder. In that binder, I have the documents that I'm going to introduce to the witness, and sometimes I'll put little bullet points on those documents of key things that I want to get, key admissions I want to get. Sometimes there's some ambiguity about what a phrase means in a document. I might highlight that word to remind me as I'm going through that document to make sure to ask about that. But I'll also prepare sort of a very rudimentary order of proof where, you know, I will have the elements of the cause of action that's at issue, or multiple causes of action, and how I'm going to, again, assuming that I'm on the defense side, how I'm going to attack those causes of actions and the elements of those causes of action, and you know, I will have the cause of action, the elements, and then I'll have, you know, maybe identify some documents that are going to help me with that, some facts and some information that I'll need to get some admissions. And I'll have it in a nice binder. And again, that not only is helpful for my preparation, it keeps me focused and guided as to what I want to do. But then when I am taking the deposition, it has the added benefit of sort of optics, that I have everything nicely organized. You know, I'll throw some extra those flags just to, from an optics standpoint, whoa, this guy has really gone through everything, and he's very diligent and he's very focused. And again, it has some optic value, some perception value, which can go a long way, and it's something that I encourage you to do. Okay, so now we've talked about part one, and now we're going to focus on part two, which is preparing your client. Now, obviously, when we're talking about client preparation, it's going to be focused more from the standpoint of you defending the deposition, right? Because your client is going to be there, you're going to be defending the client. So really this part, and a lot of what we talked about in the preparation was more focused on when you're taking the deposition, but all of that comes into play when you're defending the deposition as well, to know the facts, the law, and the like. But now when we're talking about preparing the client, we're really going to focus on when you're defending the deposition and what you need to do. Okay, so there's lots of rules when we're talking about the client. Okay, now first thing you want to do is manage the client's expectations. Okay, now what does this mean? Well, a lot of this is going to obviously depend on the level of experience your client has with depositions, but you want to start with the basics, right? The who, what, when, where, why, and how. So who is the client in this case? The client is being deposed. Where is the deposition taking place? The deposition is going to take place in a conference room, probably. It's going to be in a conference room. There's going to be a court reporter there. There's probably going to be a videographer there. There's going to be opposing counsel. There may even be a party witness there. A lot of times that can be unsettling to the client. So it's very important to tell the client the who in terms of who's going to be there, and it's always going to be more than just the client. It's also the where. Give them a sense of the room. And I try to do the preparation in a conference room as well, so that helps create some familiarity with the room where the deposition will likely take place. Okay. Then we're going to go to the when, as we talked about, is important to confirm, but that's really not a key issue when it comes to preparation. And then we're really going to go to the what, the why, and the how. Okay. So we're going to start with the what. What is a deposition? Well, to some people, that's an obvious, it's obvious. A deposition is a discovery device that's, used to obtain information about your adversary's claims and defenses, okay? And you can recite that, and you can recite all the rules and the codes and everything like that, but that's really not going to tell your client anything. A lot of clients will think that a deposition is sort of a mini trial, and they're going to expect at the deposition that you being the attorney is going to engage with opposing counsel, and you're going to argue with opposing counsel, and you're going to be the soundpiece for the client and have the client's voice heard during the deposition. A lot of times clients think the deposition is the client's time to talk, right? If you're talking from, let's say, a plaintiff standpoint, you filed the complaint, you've been wronged, you've been aggrieved somehow, and depositions don't happen right away. You're talking 6, 9, 12, sometimes longer down the road. The client is going to be deposed. Now finally the client has a chance to be heard, and the client wants to be heard. And so this is often, when I'm talking to clients, I can't wait, I'm going to tell opposing counsel this, I'm going to tell opposing counsel that, and I want you as my attorney to be there to back me up and to yell and scream at opposing counsel and tell him that he should, agree to my demands and we can resolve this case. Now, unfortunately, that's just not the way that it goes. So you need to really manage the client's expectation and tell them what the deposition is. Now, if I am defending the client in the deposition, I tell the client that this is a defensive exercise, which means the goal when your client is being deposed really is for the examining attorney to leave the deposition without any new information, okay? And sometimes that's a difficult goal to obtain, but that's really the goal that I like to have, number one. And number two, I'd like to make sure, and we'll talk a little bit more about this as we go through part two, is about when you're preparing the client, I want the client to leave the deposition saying to me, you know what, I was prepared for every single question. You during the preparation went over all these questions and then some, and there was nothing that the examining attorney asked me that I didn't already go over with you during the preparation. So really those are the two goals. They're lofty goals, but those are really the two goals that you want to have as you're going through the preparation process. But it starts with managing the client's expectations, because I've been in depositions where I've achieved that first goal, which is that the opposing the questioning attorney did not get any new information, okay? But I didn't, engage in tactics, and we'll talk more about those engaging things in part 3. So it didn't look like I wasn't being overly aggressive. I wasn't arguing with opposing counsel, and then the client seems unsatisfied and thinks that I was not advocating enough on the client's behalf, right? I've been in some depositions where I have had to get into a little bit of a back and forth and engage in some of the tactics that opposing counsel was initiating. And they haven't gone, and for whatever reason, they weren't as successful as I would have hoped. And the client has come to say, that was fantastic. You were really in there advocating for me, okay? So those are examples of bad preparation. You want to make sure that the client knows what the deposition is about. And so I always tell the client, this is not your chance, this is not your time to talk about your case. This is not. This is a defensive exercise. We want to make the questioning attorney work for every bit of information, and we're not going to give information unless it's asked, and we're going to really make it a long, arduous process for opposing counsel. Okay. So that's sort of on the what is a deposition. Okay, and then there is also, okay, well, why am I being deposed, right? And this is important when we talked about this in part 1 in terms of why are you taking the deposition? Well, from the defense standpoint, you need to ask yourself, well, why is opposing counsel, why do they want my client? Now, sometimes it's obvious. I'll use that slip and fall accident again, right? You represent an individual who fell at a department store, and department store wants to depose your client, obviously, to learn about the extent of the injuries from the fall. Okay, that's a pretty obvious indication of why you want your client, why the other side wants your client deposed. Sometimes it's a little more subtle. They might have some information about the claims. You sort of, the other side doesn't really know. And you have to really explain to the client where the client fits in. Now, this is important not only for your preparation, but it's also important for the client, because the client then feels sort of invested in the process, right? A deposition is a very unnatural process for a non-lawyer and even just non-litigators, right? So if you help give the client a sense of, okay, you have a very important role in this case. Your role here is the other side is trying to find out information about X. Your role is to make it as hard as possible for them to find out information about X. That really helps the client feel invested. That helps the client sort of stay on board with the defensive exercise. It sort of gives the client some marching orders. And to use a big law buzzword, it gives the client a little sense of ownership in terms of what it is, what is this process about, and how do I fit in, okay? So now that we've gone ahead and we've managed the client's expectations, right? This is a defensive exercise. This is not an opportunity to win your case. This is an opportunity to prevent the other side from getting key information. We want to find out what it is that the client knows. Okay? And the best way to do that is to let the client talk. When you have a meeting, ask the client, why do you think you're here? Get a sense from the client of why, what they know about the case, and really let the client speak openly, extemporaneously. And this does a couple of things, okay? Number one, it really gives the client a voice. Again, the deposition doesn't happen right after you file the suit. A lot of times the client feels as if his or her voice is not being heard through the litigation process, and this allows the client really to sort of get everything off his or her chest in terms of the litigation. But for your standpoint, it helps you know from the client how much does the client know, right? Does the client know this information very well? Does the client know certain aspects very well, but is sort of not as well versed on other aspects? Does the client use, I guess, unfavorable phrasing to characterize certain things? and we'll talk more about this when we go into how to answer a question. But is the client saying, instead of, I drove through the intersection, is the client saying I raced through the intersection? We want to avoid phrases like that, right? So we're getting what the client knows, but we're also using this information to help us in our preparation. Now, sometimes the client knows something that you didn't know beforehand for whatever reason. And so it's important, as you're going through this process, to continually update your own preparation, right? So I should have switched over the slide a little bit sooner, so I apologize. But when you're meeting with your client, it's going to be after, ideally it's going to be in person. It's going to be after you've already gone through some preparation. But preparation for yourself is an ongoing process. So as you talk to the client, get information from the client, sometimes you're able to work through certain issues that are some sort of unanswered questions, or I want to know from you, what do you think about this specific fact or this specific allegation? You want to get that information, and you want to be able to incorporate that into your preparation as well. And it's very important, as you go through this preparation process, is to encourage candor, right? You want to remind the client, of course, of the attorney-client privilege, but you also want to let the client know that if there's bad information out there, I need to know about it now so I can deal with it, right? I'd much rather hear about it now than on the witness stand at trial. So tell me everything, and I always tell the client to be over-inclusive. I will be the one to decide, what information I need, what information I don't need. So I encourage a very candid, open conversation. Okay? So now we've done 2 steps of the preparation of the client. We've sort of managed the client's expectations. The client has an understanding, hopefully, of what the deposition exercise is, and more importantly, why that client is being deposed. And then sort of the client has a marching orders, has sort of a mission in mind. Okay? And now we also know, what does the client know? And perhaps more importantly, what they don't know, and how do they convey what they know, right? And as we go through what the client knows in that initial meeting, we can also sort of gauge the level of sophistication of the client. Is this client someone that's going to need multiple preparation sessions? Is this someone who speaks very well, speaks very eloquently, answers questions directly, has a good vocabulary, has a good grasp of knowledge of the issues, sort of understands his or her role? Or is this someone that just wants to talk, and no matter how many times you tell them what the procedure is, they keep asking you, well, when are you going to argue with opposing counsel? Those are things that you're going to want to know as you those are things you're also going to want to gauge as you go through the initial process. Okay, so we're going to talk now about how to answer questions. Okay, and I always like to start this part with an example. And again, a deposition is an unnatural process. It's unlike usually, it's usually a one-time experience for a client. Obviously, some clients have been deposed multiple times, but usually it's a one-time experience. And so the client is unfamiliar with the deposition, is unnerved by the deposition, quite frankly. There's a court reporter, you're under oath, and it's a little bit off-putting. But you have to remind the client, this is very unnatural. So how do I do that? I start with an example, okay? If I tell the client, if I'm outside, if the client is outside and a stranger walks up to the client, and the client, for this example, is wearing a watch, somebody asks the client, do you know what time it is? What does the client say? The client says, looks at the watch, says, yes, it's 11:30. That's wrong if you're in the deposition, right? You almost want to be, I tell my clients, and I use a different word sometimes, so you just want to be a jerk in the deposition. And sometimes that's a very easy way to explain how to be in terms of how to answer the question. So when I ask my client, do you know what time it is? Their answer should be not, it's 11:30, not, Yes, it's 11:30. It should be yes, and that's it. And this, of course, assumes that the client, has access to a clock. Because if the client doesn't have a watch or a clock, the answer should be no. Or, okay, so it's very unnatural because outside somebody asks you the time, you're anticipating they want to know. The other person doesn't want to know if you know the time. The person wants to know what the time is. So it's very natural outside of a deposition setting to want to volunteer that information and give that information to the client, to the examining attorney. But now is not the time. And I start my deposition preparation in terms of answering questions with that example. And I think that example sort of resonates. It's something that they can remember and call back on. And it's something that I often, leading up to the deposition, as we're walking into the deposition room, I will remind the client this example. Remember, you're in a deposition, you might be the nicest person in the world outside of the deposition, but here we're asking you, if the questioning examiner says, do you know what time it is? What is your answer? Yes, and that sort of helps put them in the mindset of the deposition process, that it's an unnatural process. You do come across as somewhat of a jerk because, hey, everybody knows what you want to know, and that's the actual time, but you're not going to give that information to the questioning attorney. Okay, so really that's sort of the foundation of how to answer the question. Now, when we're actually answering the question, there's 4 little parts that I like to go through. And the first part is, of course, you have to answer with the truth, right? We're obviously not going to condone untruthful answers. We're certainly not going to encourage untruthful answers. We want the client to tell the truth, okay? But we want the client to do so following a 4-step process. And before I go into the process, I want to talk about why that process is important, okay? It's important really for 2 reasons, one for the client and one for you. The first, for the client's purposes, again, this is a very unnatural process. And so this allows the client to sort of have a rubric or a framework to go through before answering questions that the client. So normally if someone, asks, hi, how was your day? I had a great day. I first went to the beach, and then I went here and I went there, and you just want to continue to talk and talk and talk. And by having sort of this little ask yourself these questions, this rubric in place, it really stops the client from going into that natural reflex of just answering the question and going on. So it forces the client to think before answering the question. And then for your purposes, it gives you time to assert your objections to the examining attorney's questions. And we're going to talk more after the break about objections and why they're important. But one of the most frustrating things when you're defending a deposition is if the timing is off between the client and yourself. So, for instance, if there's a question and the client answers the question and you're right about to object, it's hard to have a ambiguous question, ambiguous objection when the client says, "Oh no, I understand the question. I'm going to answer it." That just it doesn't really work. So having that 4-part rubric in place really serves both of those purposes. Now, I think we're going to talk more about. We're going to sort of take our break now. We're going to pick up here in terms of the 4-part rubric and proceed with the preparing your clients for deposition purposes after the break.